Thank you. The result of the vote on motion 19429 in the name of Graham Day is yes 86, no 29. There were no abstentions. The motion is therefore agreed. We will now move on to the next item of business, and the next item of business is Stage 3 proceedings for the Land Reform Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 44A, the marshalled list and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of the Stage 3. The period of voting for the first division will be 30 seconds. Thereafter, I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press the request to speak buttons or enter the letters RTS in the chat function as soon as possible after I call the group. Members should now refer to the marshalled list of amendments. I turn to Group 1 on public rights of way, and I call Amendment 232 in the name of David Torrance, grouped with Amendments 234, 264 and 321, and I call on David Torrance to move Amendment 232 and to speak to all amendments in the group. Mr Torrance.
Thank you, Presiding Officer. This is the first of my 2 amendments to this bill, which will enable a resolution to issue of access to Burnt Island Harbour. The 2003 Act includes, amongst other provision, a right of responsible access to land, commonly called the right to roam. The Act breaks this right into constituent elements: right to be on the land for a purpose set out in the Act, and the right to cross the land for a purpose set out in the Act. The amendment provides a confirmation that asserts rights of access, for example, rights of way gained by prescription, that is the right of way established through use of in accordance with certain further conditions, are included within the right to cross land. It is relevant here to recognise that most rights of way and relatively rights established by prescription rather than rights established through designation by a relevant authority. This is a helpful clarification of a law rather than an extension to a law. It simply recognises the reality of rights of way by prescription and helps all understand that the proper execution of such rights are covered by the Act. This is important in its own right, but also directly relevant to my subsequent amendment, which refers specifically only to Burnt Island Harbour. Burnt Island Harbour is the reason that Burnt Island exists. It's a subject on the town's coat of arms. Ships may no longer be built there, millions of tonnes of coal may no longer be exported from there, or bauxite for Scotland's aluminium industry imported. Yet the harbour remains, or rather remained until February 2023, a much-loved place of public resort. Dogs were walked there, bikes were ridden, children fed Sammy the harbour seal, whales and boats were watched, and fish were caught by locals and visitors alike, including myself as a boy. Yet in February 2023, the first time in the town's history, the community was completely fenced out from all waterfront areas. This historic Grade B listed harbour was out of bounds. Neither locals nor visitors could access the harbour in any way that generations of us had always done. My constituents, represented by Burnt Island Harbour Access Trust, have campaigned relentlessly for the rights of access over the last 2.5 years. And recently, for example, hundreds of people marched and rallied in support of harbour access. Thousands have signed a petition against the fence, and hundreds have written to all council or councillors or MSPs, and expert legal opinion has been paid for by the community, and numerous requests for compliance have been made, yet the fence remains. 2 years ago, Burnt Island Harbour Access Trust commissioned legal opinion from lawyers BTO. This confirmed that the rights of access apply to the harbour. More recently, Professor Rodley Paisley, Chair of the Law at Aberdeen University and prominent legal scholar in this area of law, has taken an interest. His opinion robustly supports the views of my constituents, and it is following his direct advice that my constituents approached me to specifically lodge these amendments to the current bill, which I am happy to do so. Through my simple amendments of 321 and 232, the Scottish Ministers are required to determine, in accordance with existing law, areas of public resort and rights of way at Burnt Island Harbour. The move is supported by all Mid-Scotland and Fife MSPs from across all parties, and indeed all elected representatives for Burnt Island at all levels of government have given their support for this crucial important issue for Burnt Islanders, and for all the many visitors that could be resolved for once and for all. I know that this amendment is imperfect, and can I ask the Cabinet Secretary if she considers there are a more suitable route forward to address this issue, which is crucial to my constituents of Burnt Island, and if she could set that out.
Thank you, Mr Torrance. I now call Mark Ruskell to speak to Amendment 234 and other amendments in the group. Mr Ruskell.
Thank you very much, Presiding Officer. There is a really key question at the heart of this bill. Does this bill address the battles over land rights, concentration of power, access and ownership across Scotland that so many communities find themselves struggling with? And the amendments in this group are an early test for the government at stage 3, because the concern that myself and David Torrance and many other MSPs are raising is a real one being faced by a real community in Burnt Island, an issue where rights of access that have been asserted since Victorian times are being trampled over by Forth Ports, while Fife Council have been completely ineffective at upholding these rights. And this is all happening within an area of a green free port, which we were told would deliver incredible economic opportunities for communities. But so far, not only have the jobs not materialised at Burnt Island, but now people are being fenced out of their own community. They have serious questions about the effectiveness of Fife Council in holding Forth Ports to account, given the deep pockets and economic power that Forth Ports hold locally. And I welcome that members of the community have come to Parliament today and have engaged with MSPs and I believe the Cabinet Secretary in conversation about the struggle that they face. Now, this bill could have been an opportunity to try and improve the enforcement of access rights, not only for the community at Burnt Island, but for many more across the country. And I have constituents at the other end of my region, for example in Glen Lyon, who for years have been unreasonably denied access to the North Chesthill estate. Again, a lack of consistent enforcement action by Perth and Kinross Council has been raised. Now, Ramblers Scotland, in their briefing for this debate, highlight that there is a growing concern about a gap between Scotland's access rights on paper and their effective application. Councils in their roles as access and planning authorities are in some cases proving ineffective at upholding and enforcing these rights long established in common law. We're now 20 years on from the production of guidance on Part 1 of the 2003 Land Reform Act, which was designed to help enable councils to operate effectively as access authorities. But so far, no updated guidance has ever come forward, despite 2 decades of real-life experience in working with the Act. So I would ask the Cabinet Secretary to commit to finalising the review and publishing that updated guidance. Now, I welcome David Torrance's amendment, which is an attempt to explicitly carve out Burnt Island Harbour in law. It makes an important point. And my own amendments 234 and 264, together with 238 in a later group, seek to put in place general requirements for all large landowners to help facilitate public rights of way of their land and to engage with communities proactively about these specific rights of access. This engagement has been completely absent in the case of Burnt Island. Now, I understand through discussion with the Cabinet Secretary that there are concerns about these amendments and potential consequences. And for those reasons, I will not be moving these amendments to the vote. I would like to hear from the Cabinet Secretary what commitment she can give to engage with Fife Council on this issue, to ensure that they're upholding their responsibilities as an access authority and what they are doing to support the community, because they have manifestly failed to do that. The Scottish Government must help us to hold Fife Council to account. In conclusion, Presiding Officer, these amendments are a warning flag that access rights that appear world-class on paper are being eroded in Scotland. We need to make sure enforcement is resourced and effective. In the case of Burnt Island, it has not been. That must change going forward.
Thank you, Mr Ruskell. I call Liz Smith.
Thank you. And on behalf of the Scottish Conservatives, can I put on record our thanks to David Torrance for bringing forward these amendments, because there is an important point of principle here. And can I also pay great tribute to the Burnt Island community for the way in which they have gone about their very helpful campaign in flagging up all the issues, because I think they've done a wonderful job in that respect. And it speaks volumes when you find that the councillors and the MSPs agree on this issue. Nonetheless, I think it's clear from what the member said himself that there are issues. We understand there are potentially legal issues that have to be explored, and I'll be very keen to hear from the Cabinet Secretary exactly what these are and how these can be dealt with in order to proceed, so that we ensure that the Burnt Island community has justice when it comes to this whole issue. Thank you.
Thank you, Ms Smith. I call Edward Mountain.
Thank you very much, Presiding Officer. And I rise to speak to these amendments, and I'm interested in the points that Mark Ruskell brought forward with his amendments about the Scottish Outdoor Access Code. As he well know, I've been trying to get the Scottish Outdoor Access Code reviewed for the last 5 years, which the government has steadfastly refused to do on the basis, I don't know what their basis is, but my view is it's 20 years old and it probably needs an update. I'm not sure that I could support his amendments if he moved them, which I'm glad to say he's not. But I would say that on Mr Torrance's amendment 232, what slightly concerns me about this is how you assert a right of access. I mean, some rights of access will be asserted because they've been taken with consent, with consent, with payment, or as a fact of law. And what I'm not sure is whether those would still stand under his amendment, but I understand what he's trying to do in Amendment 321, and bearing in mind what the local MSPs are saying, I will follow their lead on whether it's a good one to follow when they've heard from the Cabinet Secretary. But I am worried that the amendment 232 is a bit wide-ranging for me and doesn't define where access actually lies and how you go about asserting it. Thank you, Presiding Officer.
Thank you, Mr Mountain. And I call Claire Baker.
Thank you, Presiding Officer. I'll speak to the amendments from David Torrance and Mark Ruskell in this group, and I think they are trying to find a pragmatic way forward in terms of addressing the current restrictions on public access to land at Burnt Island Harbour and in any similar circumstances elsewhere. The amendments in the name of David Torrance apply specifically to the historic East Dock at Burnt Island Harbour, recognising that the community has a particular set of circumstances. It is a breakwater that was originally built in Victorian times and a heritage of public use that existed until fences were erected and gates were locked. It is currently home to a sailing club, a redundant caustic tank, derelict land and a pallet factory that depends on road transport. Access to this land is something that matters a great deal to many in the local community, as evidenced by the correspondence that I and other members representing Burnt Island have had on the matter, and there is a strong local campaign to restore access. Prior to its closure, the dockside land was used by fishermen, dog walkers, cyclists, nature lovers and visitors, and many in the community feel the closure was unjustified. The amendment does not assert that a public right-of-way exists. It requires a proper review and determination to be made as to whether this is the case, while also allowing the concerns of the landowner and the port operator to be addressed. This, I believe, is a balanced approach that can provide a means of progress on the matter. One of the challenges for those campaigning against the removal of public access has been securing appropriate legal advice, which the local authority was not permitted to do, and this amendment would seek to resolve that by ensuring the provision of expert advice alongside sufficient time for a definitive decision that resolves the issue and binds parties to that decision. For decades, people have been able to enjoy the waterfront as part of their daily lives, walking freely on the breakwater and enjoying the harbour environment, just as many other communities are able to do so around Scotland. Burnt Island Harbour Access Trust are not looking for confrontation, but for us to listen to their voices and provide them with clarity and a potential solution. While the amendments in Mark Ruskell's name are not specific to Burnt Island, they offer a general mechanism that would allow communities in a similar position to seek a solution. I attended the meeting today with the Cabinet Secretary and members of the campaign group. The Cabinet Secretary indicated that she was not minded to support these amendments. I will listen carefully to her arguments, and if Mr Torrance and Mark Ruskell decide to withdraw or not move their amendments, I would have to ask what the Government suggests the solution is. To be clear, if the members do move the amendments, we will be supporting them this afternoon. But if these amendments are not taken forward today, the campaigners will be sorely disappointed and they will feel further from a resolution than ever. They have highlighted a valid concern and an inequality in resources when attempting to challenge a decision they don't accept. I would urge the Cabinet Secretary to pay attention to the situation faced by the Burnt Island community and this afternoon commit to finding a solution which balances the rights of all involved. I would be seeking those assurances before making a decision on how we go forward with these amendments. The amendments in this group do seek to strike a balance between those in the community with an interest in walking and using the harbour and Forth Ports who have raised concerns around safety, liability and operating requirements. Our role here as legislators is not to determine the outcome of that debate, but to facilitate clarity and resolution, which these amendments seek to do. They offer a way to apply the bill's underlining principles of accountability for landowners, fairness to communities and clarity of rights in a specific and tangible solution. I don't believe they're heavy-handed, nor do they prejudge the outcome. Instead, they commission the proper review and determination that the community deserves.
Thank you, Ms Baker. I now call in the Cabinet Secretary.
Thank you, Presiding Officer. Firstly, I want to deal with Amendments 232, 234 and 264 together because they aim to achieve essentially the same thing, which is to place an obligation on landowners to identify rights of way and ensure that people can exercise their rights to use the identified route. Now, public rights of way are traditional routes that are established under common law with no single statute governing them. To be a right of way, a route must meet a set of 4 conditions, which relate in summary to its long-term use between 2 defined points. However, Scots law doesn't require a right-of-way to be recorded. Any route that meets the conditions to be a right-of-way is a right-of-way. If it is not agreed that a disputed route meets the necessary conditions to be a right-of-way, it's up to the courts to decide whether the criteria are met. Now, the right of responsible non-motorised access to land conveyed by Part 1 of the Land Reform Scotland Act 2003 is really world-leading in terms of its progressive nature, its extent, its scope and its clarity. The Act's statutory guidance, the Scottish Outdoor Access Code, defines both how individuals should exercise their access rights responsibly and the responsibilities of landowners with respect to access rights. Now, there are already provisions in the 2003 Act which empower local authorities to, say, remove prohibited signs, obstructions or dangerous impediments where landowners have failed to comply with written notices requiring remedial action, as well as the ability to take measures for safety and protection with respect to both access rights under the 2003 Act and to public rights of way. Now, these amendments are therefore not necessary for 2 reasons. First, there is no requirement to record rights of way in Scotland, and second, the new requirements it's proposed should be imposed on owners in the amendments would duplicate provisions in the 2003 Act, which already help to ensure the proper exercise of non-vehicular rights of way. Although the amendments are clearly intended to deal with specific cases where individuals have identified issues with the way that access is managed, in practice they would impose a significant new burden on a very wide range of people, which isn't justified. The requirements for land management plans already require that the owner should set out how they are complying or intend to comply with the Scottish Outdoor Access Code, and the regulations can then set out further detail to require land management plans to set out information about access rights and rights of way and how these are being supported. Now, I just want to turn to the substantive amendment that we're discussing today, in Amendment 321. And just to say, I really appreciated the opportunity. I think Mark Ruskell had invited the Burnt Island Access Trust into Parliament today. I really appreciated the opportunity to meet with them and hear directly the strength of feeling that there is around this, as I'm also picking up from the MSPs across chamber today. Now, I completely understand that deep frustration, and in a moment I'm just going to turn to what I think needs to happen from here. But for now, I cannot support this amendment because I can't in good faith support an amendment and promise that it will deliver a solution, because this amendment does not deliver the intended outcome. Now, it has a number of drafting issues. For example, places of public resort isn't defined in legislation. This means it doesn't clearly give ministers or other authorities the ability to overrule decisions taken by the Ports Authority, the Council or any other body that has a role in the decisions to which the Trust object. Now, this is in large part because this amendment doesn't change the roles and responsibilities for the Local Access Authority, the local council in this case. Now, there is also a high risk of unintended consequences. This is particularly true as some matters relating to port access are reserved to the UK Government under the Harbours Act. So far from bringing a solution, the uncertainties in these amendments could cause such confusion and complication that a solution is more difficult to achieve. I don't think anyone in the chamber would welcome that, and we should all be very wary of, I think, the good intentions, but which would essentially lead to even more challenging outcomes. However, that being said, I do take these issues seriously, and I think following the specific ask that David Torrance has asked of me today, I want to set out what action I intend to take from here. Now, first of all, I am deeply concerned by what I've heard, both directly from the Trust and from other MSPs. I am happy to make the commitment that Mark Ruskell asked for, and I'll be seeking a meeting with both Fife Council and the Port Authority urgently to seek greater clarity on this issue, and I want to ensure this happens at pace. Secondly, it's particularly worrying that there are concerns with the local community about how the Council, as the local access authority, is fulfilling their duties. In my representations to the Council, I will be seeking to understand how they've been carrying out their duties under the Land Reform Scotland Act 2003. And thirdly, I want to meet with the Access Trust again, as well as their MSPs, to better understand these issues myself. I'll discuss these matters with all relevant authorities in order to satisfy myself that everything that can be done is being done to ensure our world-leading system of access rights is being respected and upheld, and ultimately that we're looking for a solution. And fourth, I am aware that guidance to local authorities on these issues hasn't been updated in some time, and that's where I'm happy to meet with MSPs involved in this to discuss a process for updating this important guidance. So, therefore, while I'm unable to support the amendments in this group for the reasons that I've set out, I hope that the commitments that I've set out to Chamber today will satisfy both David Torrance, Mark Ruskell and other members across the Chamber that I do take these matters seriously. I want to find a way forward, and with that I would ask them not to press their amendments.
Thank you, Cabinet Secretary. And I call on David Torrance to wind up and to press or withdraw Amendment 232.
Thank you, Presiding Officer. I welcome the Cabinet Secretary's commitments, and I recognise the legal issues around the amendments that I have proposed. Can I say everything that she says is most welcome, especially from Burnt Island Harbour Access Trust and to my constituents, but I know that she will be held to account to keep these promises, not only by myself but especially by the community of Burnt Island, and I will not be moving the Amendment 232 in my name.
Thank you. David Torrance seeks to withdraw Amendment 232. Does any member object? No member objects. Amendment 232 is therefore withdrawn. I turn to Group 2, obligations to consider the public interest. I call Amendment 115 in the name of Rhoda Grant, grouped with amendments as shown in the groupings. I call on Rhoda Grant to move Amendment 115 and to speak to all amendments in the group. Ms Grant.
Thank you, Presiding Officer. I move Amendment 115. Amendment 129 would ensure that the public interest would have to be at the forefront of land management plans. Acting in the public interest is a well-understood concept and should be at the very heart of this bill, but sadly it's missing. The public interest test also outweighs individual interests. Land management plans could be an effective tool for making Scotland's land work in the public interest and in some circumstances lead to diversifying land ownership. Therefore, the bill needs to be strengthened. These amendments have taken on board discussions at Stage 2 about the narrow focus of the bill on community sustainability. This is the policy goal as stated by the Scottish Government, and this amendment reflects changes from Stage 2 to incorporate some but not all of the public interest considerations relating to community sustainability. Greater clarity is needed on the considerations which will shape the guidance underpinning land management plan, which more firmly centres on the public interest in land management plans. This would make it more transparent from the outset for landowners, communities, the Land and Communities Commissioner and Scottish Minister what types of consideration should underpin land management plan. Amendment 261 therefore requires Scottish Ministers to publish guidance on how landowners incorporate this into their land management plans. Amendment 115 is consequential to 129 and Amendment 233 is consequential to 261. I also support Mercedes Villalba's Amendment 76 and 76A, which seeks to ensure that buyers of land also face a public interest test. Ariane Burgess' Amendment 15 seeks to do something similar, but it's the same as Mercedes Villalba's amendment at Stage 2, which was not supported by Scottish Government. And while I support both amendments, I hope that the Scottish Government and the Cabinet Secretary will take into account the updated version of the amendment submitted by Mercedes Villalba and now support it.
Thank you, Ms Grant. I call on Edward Mountain to speak to Amendment 43 and other amendments in the group. Mr Mountain.
Thank you, Presiding Officer. My amendments in this group are to do with lifting the prohibition order. Amendment 43, if enacted, would add a general public interest ground. This would mean that ministers must lift the prohibition on the transfer of a large land holding if they deem that it would not be in the public interest to continue to apply the prohibition. In the bill as drafted, there is a fundamental flaw that the government may want to buy land holdings themselves, and they therefore would prohibit its sale on the basis that it is in their self-interest to do so, which frankly in my mind is not good practice. Amendments 44 and 45 are consequential to Amendment 43. Speaking to the other amendments in the group, Presiding Officer, Amendments 129 and 261 in the name of Rhoda Grant place huge obligations on landowners, including the breaking up of farms, transferring their energy resources to community, giving up land for housing, creating new crofts, which may be outside crofting areas. All of these make it virtually impossible for the landowner to function and run their businesses. This will have an adverse effect on their ability to gain finance to carry out the projects they wish to action. The fact these powers are then devolved to the Scottish Government to identify how they will be enforced in each management plan adds an unhelpful and bureaucratic level of administration and complexity. I find Ariane Burgess' Amendment 15, in apparently that you can only sell land to someone who lives in Scotland, strange. I'm sure Ms Burgess knows that the large foreign investment in Scottish land holdings, which have been hugely beneficial to Scotland. For example, you could argue that Anders Poulsen of Wildlands and Danish companies in the Highlands have contributed to building up sustainable communities, and in the case of the latter one, ensuring that the local community school is kept open despite the fact the local council wanted to close it. Limiting the future sale of that land will limit the desirability of that investment, and Ariane Burgess probably knows that running large estates costs a huge amount of money, something that the government doesn't have. And I will give way.
Ferguson.
Does Mr Mountain agree with me that if Ariane Burgess' amendment had existed in law some years ago, then the aluminium smelter at Fort William would have been shut because it was a foreign owner that kept it alive?
Edward Mountain.
Well, I'm not sure I'm going to go quite with Ferguson on that, because the question is on the agreements that were perhaps agreed with the foreign owner to keep the aluminium smelter, perhaps maybe something that come back to haunt the government in the future. But what I can say that running say a 20,000 hectare estate will cost in the region of £500,000 each year, and that's taxed income it comes from. So it is a true investment. I really don't like her amendment. In the terms of Mercedes v Alba Amendment 76, well, I understand her aim. Her amendment relies upon the government approving future management of land. I have to say that 40 years of land management, not everything I've done regarding land management supports the government's objectives. For example, in the climate change, the last thing I'd be doing is introducing beavers all over the countryside to eat trees that we have spent years funding, and why we now consider that beavers are better for eating trees than the deer, which we spent years trying to kill. The government is in a position to make that decision. As far as preparing guidance, I struggle to understand that the government will do that in the short term, and my concern is that we could be waiting another 10 years, which by that time will be time for another land reform bill, because the other one's considered irrelevant. Now, I think I'll leave it there, Presiding Officer, so I don't incur your wrath at this stage, as I may do later. Thank you.
Thank you, Mr Mount. It's never a good idea to give the Chair warning of the potential for incurring the Chair's wrath. With that, I call Ariane Burgess to speak to Amendment 15 and other amendments in the group.
Thank you, Presiding Officer. This bill has been long in the making, and yet after many hours of deliberation, it seems that it hasn't progressed much further than where it started. And I remain deeply concerned that the measures do not go far enough in addressing the issue at the heart of land reform, that the majority of Scotland's land is owned and controlled by a minority. Let's see where we get to over the course of the next 2 days. A key concern that I have about this legislation is that it does not do nearly enough to ensure that public interest considerations are at the heart of the new measures. The need for a public interest test has been discussed at length over the course of this bill. It formed part of the Scottish Land Commission's recommendations for this legislation and was included in the government's public consultation. Several variations of public interest amendments were discussed at stage 2 from several parties, but none of them have made it into the bill. The transfer test introduced by ministers is a disappointing watering down of the Scottish Land Commission's original recommendations, and indeed, in general, this bill, as drafted, has drifted away from the Commission's original premise for this bill. A critical element that is absent is ensuring that buyers of a large land holding or lotted land will act in the public interest. Scotland has a deeply unfair concentration of land ownership in the hands of a minority who are often absent and seeking only to extract wealth for themselves rather than redistribute it. And my Amendment 15 would introduce a public interest test on prospective buyers of large land holdings. It would require that buyers of large land holdings are upfront about how they intend to manage the land. The test would also introduce 2 key criteria. Firstly, that a prospective buyer who already owns 500 hectares would not be able to pass the test unless it could be shown that their management of the land would have significant environmental or community benefit. And this would help to end the growing concentration of power in our land ownership pattern. Secondly, that ministers would have to consider the prospective owners' tax residencies with increasing numbers of overseas. I'm not going to take an intervention. I've got a lot to get through, and I think we've got time considerations here. Secondly, that ministers would have to consider the prospective owners' tax residency with increasing numbers of overseas investors looking to buy up Scotland's rural land. Any public interest test must take this into consideration. In the original consultation for this bill, the government asked respondents for their views on a proposal to explore the possibility of introducing a requirement that those seeking to acquire large-scale land holdings needed to be registered in an EU member state or in the UK for tax purposes. 67% of respondents agreed with this proposal. This would start embedding the principle that there are restrictions to land ownership in Scotland and that ideally landowners will be paying tax in this country and more broadly contributing to the collective wealth of this country. Now, I wish to thank the Revive Coalition for their support for this amendment, and thanks to Community Land Scotland for their thoughtful discussion over many months about how we can work public interest considerations into the bill. And I wish to note that Mercedes Villalba's Amendment 76 and 76A seek a similar outcome, and I will listen to her contribution with interest. Thank you.
Thank you, Ms Burgess. And I call Mercedes Villalba to speak to Amendment 76 and other amendments in the group. Ms Villalba.
Thank you, Presiding Officer. Let me start by thanking Community Land Scotland, who are here today, and the Scottish Parliament legislation team for their support in drafting my amendments in this group, and to everyone out there who's engaged with the land reform process. Amendment 76 inserts Part 2B into the bill, which would apply a public interest test to a proposed new buyer in relation to transfers of large landholdings. It would work by requiring ministers to have regard to the identity and management proposals of the buyer, including how much land they already control and any plans they have for the land. Amendment 76A then amends this new part to insert a presumed limit on ownership. The presumption being that a transfer to a buyer who already controls more than 500 hectares would not be in the public interest unless otherwise demonstrated through environmental benefits, community sustainability or other means. Members may remember I consulted on these issues in my proposed land ownership and public interest bill earlier in this parliamentary session. This followed an investigation into issues associated with large-scale and concentrated land ownership in Scotland by the Scottish Land Commission, which found that, and I quote, harmful concentrations of power in relation to land do exist and appear to be causing significant and long-term damage to the communities affected. The Scottish Land Commission went on to recommend that a public interest test at the point of transfer of significant land holdings be introduced, but the Scottish Government's bill included no such test. So at stage 2, I brought forward Amendment 174 to insert a forward-facing public interest test into the bill, and Amendment 174A to insert a presumed limit on ownership. Unfortunately, at that time, the Scottish Government was not able to support my amendments. As the Cabinet Secretary said, and I quote, "The amendments are not supported by the evidence base. The interference in property rights that would result from those proposals would require a rational and coherent justification based on evidence." She then went on to claim that the evidence on which she had proceeded is concerned with the effects of concentration of ownership on communities, and that there was no rational link between that evidence and a public interest test on a buyer. So, having worked with Community Land Scotland on the evidence base for this issue, using research from the Scottish Land Commission, and having revised these amendments to focus on the public interest connected to community sustainability, I've brought them back today. Now, I recognise that the bill does now contain reference to the public interest test, but this is a test on the land holding itself rather than a test in relation to land owners. And it is the buyer that matters because of their plans, their interests and their priorities. Public bodies like Nature Scot have shown that it is possible to sell using a test on the buyer, so we know it can be done. Scotland's land is concentrating into ever fewer hands, so we know that we do need to act. So what I'm proposing today is the most very basic of considerations on buyers of large land holdings, because there is currently a double standard that exists between wealthy landowners and the rest of us. If my constituents want to rent a room or buy a house, there seems to be no end of checks they must pass to demonstrate that they're suitable tenants or prospective owners. Can they afford it? Are they in debt? What's their credit score? Where were they before? Where will they live now? Who else will be living with them? The list goes on and on. Yet currently anyone, anywhere in the world, can buy up as much of Scotland as they like, no questions asked. It doesn't matter what they're going to do with it or how their plans would affect their neighbours. It is absurdly unjust. The Scottish Government cannot expect my constituents to believe that rules that apply to them are vitally necessary, due diligence, yet no checks can be applied to prospective buyers of land because of property rights. So I'm calling on the Cabinet Secretary to do the right thing, to be bold and to take the first step in righting this wrong. Support Amendment 74 and 74A today. Thank you.
Thank you, Ms Vialba. I call the Cabinet Secretary.
Thank you, Presiding Officer. And I really want to thank members for their contributions in the debate so far on this grouping. I do want to start by responding to the amendments directly from Ariane Burgess and from Mercedes Vialba. Now, the concentration of land ownership in Scotland is an issue that's hundreds of years in the making. And this bill will finally give ministers powers to split up land holdings when this is in the public interest. This is a huge step forward, but it is just the first step. Addressing the inequality in Scotland's land ownership isn't going to be quick and it's not going to be easy. And we can expect that those that currently own vast portions of Scotland's land are going to resist that progress at every step. But I believe that land reform is crucial to a fairer Scotland and that it is worth that fight. But we need to make sure that we don't make it easier for those who want us to fail. We need to make sure that when we bring forward proposals, we can be confident that they're supported by evidence, that they will work and that they are proportionate. Yes, I'll take the intervention.
I'm most grateful to the Cabinet Secretary for giving way. Would it not, Cabinet Secretary, be a far better, more effective strategy, rather than to create the division, bitterness, expense, bureaucracy, with one suspects very little consequence at the end of this bill were it to pass? Would it not be better to work with landowners, many of whom are providing immensely to their areas, some are not, but would it not be a better strategy to work with landowners rather than create division, animosity, rancour, ill will, tension, conflict, which will likely prevent the very aims that we both wish to see achieved in rural Scotland?
Thank you, Cabinet Secretary.
Been made by Fergus Ewing there. He is absolutely right, and I know landowners close to me who are doing some fantastic work involving their communities, inviting people into the land and doing, I think, ultimately, well, what the measures are introduced in the bill are trying to achieve is really to spread more of that good practice. That's what we want to see all landowners doing, but it shouldn't be dependent on the goodwill of the landowner as to whether some of these activities take place. Now, we've seen for years, without these interventions, the concentration of land ownership is only getting worse, and that's why these interventions are so important and why I hope MSPs will ultimately support the bill. Now, while I understand the intention behind Mercedes Vialba and Ariane Burgess's amendments in this group, Regretfully, in relation to the tests that I'd set out, I don't think they meet them. These amendments would result in property transactions being automatically rendered of no effect, apparently at any time before or after the transaction takes place, if ministers decide the transfer wasn't in the public interest. And despite the significance of this, no provision is made for compensation. There's no indication of how these new requirements would operate alongside the lotting provisions already in the bill. Now, within these amendments 15 and 76A, attempt to introduce a presumed limit of ownership of land of 500 hectares. Now, introducing this at stage 3 without that consultation, evidence or assessment of impacts on forestry, farming, other key sectors would be reckless, and it risks legislation that doesn't work. So, for example, these amendments don't actually consider the other land owned by a buyer, only land where they have a controlling interest. So under these amendments, if a seller had a controlling interest in over 500 hectares of land in Scotland, then Scottish ministers should only allow the transfer if it meets the requirements set out. But if that same seller directly owned all of the land in the area, or if they owned 10,000 hectares across Scotland, then that wouldn't be relevant. So that would create a gaping loophole in these provisions, which wouldn't deliver the policy intent that has been set out by Mercedes Villalba or Ariane Burgess. Now, voting through any of these amendments wouldn't strengthen the bill, they would wholly undermine it, and it would jeopardise its other policies. Supporting them would be a gift to those that want to maintain the status quo and want this to fail. So that's why I would encourage Mercedes Villalba and Ariane Burgess not to press these amendments and instead to engage with me on how we can build on the foundations that have been laid by this bill. I'll take the intervention.
Mercedes Villalba.
Thank you, Cabinet Secretary, for taking the intervention. And of course, I'll continue to engage as I have already been doing. But what I would like to hear from the Cabinet Secretary is what work is she committing the Scottish Government to doing on this, and when will it start?
Cabinet Secretary.
I'm sure the member would recognise this has been a long, ongoing process for a long time. Quite rightly, the focus has been on delivering this legislation and some of the key measures that are within that. The next step will then be, well, hopefully, if this is agreed by Parliament, we move to the implementation and we start to work to build the evidence that can take these measures forward in future. That's what I think the review provisions that are in Group 12 are so vital to that. I'm happy to take
Mercedes Villalba.
If you could expand, if the Cabinet Secretary could expand a little bit further on what is the threshold, what is the bar for that evidence in order to be met. I'm hearing that once this becomes an act, further evidence will be undertaken to see if something like this can come forward. But the Cabinet Secretary hasn't outlined what is the evidence that she needs to gather in order to meet the threshold to introduce these kinds of proposals. I hear from her an acknowledgement that there is a problem with concentration of land, but not any tangible commitment to work beyond this bill.
Secretary. I wouldn't say that's a fair assessment of what's been set out at all, to be honest. These are an important step forward. Of course, when we introduce measures, we need to monitor them, we need to see how they're working, we need to capture that evidence, which of course we can then build on for the future, and we have the powers in the bill to modify any provisions that we have from there. Now, turning to the amendments from Rhoda Grant, now while I agree with the public interest objectives that are listed in Rhoda Grant's amendments, regulations are the right place to set out the detail of what will be required under community engagement obligations. But I just want to highlight that we'll be supporting similar amendments that Rhoda Grant has lodged, particularly number 187 in Group 10 in relation to that. Now, these amendments would require all of the duties listed to be imposed on all landowners, regardless of the type of landholding, when preparing a land management plan. So, for example, a hill sheep farmer would need to prove that they had regard to securing a greater proportion of community-owned energy when preparing their land management plan. I don't think that would be proportionate, and it would risk plans turning into box-ticking exercises. It's better for requirements to be developed through consultation with those affected and specified in future regulations, rather than being on the face of the bill. Now, my colleague Michael Matheson has also laid Amendment 269, which would place a duty on ministers to issue guidance about the community engagement obligations on landowners. And that wider duty would cover the kind of guidance that's being sought by Rhoda Grant's amendments, but it could also cover guidance on other aspects of the obligations. So because of this, I would then ask members to reject Amendments 115, 233, 129 and 261 and accept Amendment 269 when it's considered as part of a later group. And turning lastly to the amendments from Edward Mountain. The bill, as drafted, already allows for prohibitions to be lifted where the landowner can evidence financial hardship. This is a proportionate approach that reflects this government's support for community ownership, and I would therefore recommend that members reject Amendments 43, 44 and 45.
Thank you, Cabinet Secretary. And I call on Rhoda Grant to wind up and to press or withdraw Amendment 115.
I'll just wind up quickly. Just with regards to the public interest test, the aims that are highlighted in Amendment 129 are the things we desperately need for our communities to thrive, and their absence is what leads to depopulation. It's not surprising that a landowner does not understand their importance, but they are one of the things that really, they are a group of things that really underpin the need for land reform. These are the things that community landowners do as par for the course, and we see the difference that makes with repopulation and economic development. Can I just speak quickly regarding Mercedes Villalba's 76 and 76A? Nature Scot are rightly looking at who will buy Kinloch Castle in Rum. They're putting in place checks and balances to make sure that the right buyer is found. And that's because of their pivotal role in that community. And that's the same for all large landowners. So if Nature Scot can do it, I don't see why we can't impose the same restriction on all landowners. And just for clarification with regard to the 500 hectares, yes, amendments of this kind were tabled at stage 2. They were discussed and indeed widely consulted on by Mercedes Villalba when she sought to bring forward her own legislation. So it's not true to say they weren't consulted on, and therefore I press Amendment 115.
Thank you, Ms Grant. The question is that Amendment 115 be agreed to. Are we all agreed? Yes. The Parliament is not agreed, and so there will be a division, as this is the first division of the Stage 3. I suspend for around 5 minutes to allow members to access the digital voting system. Thank you.